Okay, well, first, my name is Stephen Cobrey. I'm a partner at Cobrey & Kim. I want to welcome everybody to Cobrey & Kim's Center for Trial Advocacy, one of the presentations that we have in the series of presentations. This one is a very special one. We have an honored guest. This is Persuasive Closing Arguments, a demonstration and discussion of a closing argument in the Helio Castroneves case. I have to, because this is also being broadcast as a webinar, you have to bear with me for a second. I have to read the following. For the folks that are watching on the web, CLE has been approved in the states of California, Florida, Illinois, Texas, and New York only. For participants that wish to receive credits for other states, you must check directly with your CLE board. During this presentation, the CLE code will be announced. After the presentation, all participants will receive a thank you email. Attached to the email is an evaluation form with a space to enter the code. Follow the directions on where to return the email, and please be sure to retain this code for your records. 1 week from this date, on April 26, 2012, you will receive an email with instructions on downloading your CLE certificate. CLE credit is only available on the live day of this presentation, April 19, 2012, not during the on-demand period. Also, there will be a question and answer session at the end of this presentation. On your console, there is a Q&A box to submit questions. Feel free to write your questions whenever you like as the presentation continues. We will be taking questions from the live audience as well, so we'll try to get to as many questions as we can. At this time, I'm going to introduce my partner, Matt Menschel. Matt runs the Center for Trial Advocacy. Matt is a former director of trial training in the Manhattan DA's office, former chief of the Criminal Division in the Southern District of Florida. In the last number of years, has tried a number of significant trials and is a student of trial advocacy. And I can tell you that when we had secured Roy's attendance for tonight, we were all ecstatic, and Matt especially, because we all recognize what a real talent he is. So without further ado, I'm going to introduce my partner, Matt Menschel, who will do the appropriate introduction to Roy. Thank you.
Thank you, Steve. As Steve mentioned, I've been teaching trial advocacy for most of my career, and one of the things I love about doing this work is you never really stop learning. And we recognized that although there are a lot of great programs out there for young trial lawyers, for law students who are just going to begin their careers, there really isn't a lot of material and programs geared toward experienced trial lawyers, folks who have been trying cases for a long time, who may want to think about a new approach or a different way of doing things than they've been doing previously. And so we founded the Center for Trial Advocacy premised on the notion that we would gear the program really more toward experienced trial lawyers as opposed to burgeoning trial lawyers. And our approach, frankly, is very simple, which is to simply invite the best trial lawyers in the country and see if they will put on a presentation for you. And last year we had Ben Brothman, and this year we have Roy Black. And the approach is really just to get them to do whatever they want. And in most instances, that's been a live demonstration, which I think is one of the best ways to learn advocacy, is to watch someone who's great at trying cases actually in their element doing a part of the trial. And then afterwards, engaging that person in trying to understand the choices they made, that is to say, why they did what they did, so that we can all gain a conscious understanding of the approaches that they took. Introducing Roy Black is kind of a difficult task, and it dawned on me that there's really no reason to, because everybody that's attending this seminar, whether live or in person, I know, has heard of and knows Roy Black. And obviously his accomplishments, his successes and achievements would take up most of the day, but obviously he's very famous for trying the Will Kennedy Smith trial back in the early 90s. He's represented a bunch of notable celebrities, including an Indianapolis race car champion, Helio Castroneves, who is in fact the subject of tonight's closing argument. I was going to say that, although I've never watched the show, and I'll deny it if anybody says I have, my understanding is he's also a champion on Dancing on the Stars, which is one of my wife's favorite shows, that I would tell you. I think more importantly than discussing in detail Roy's achievements is sort of the insight I gained in communicating with Roy about this process. First of all, I found him not only to be extremely gracious in accepting our invitation to do this presentation, and for anybody, by the way, that doesn't think this requires a tremendous amount of work and preparation, I can tell you as someone who's done similar demonstrations, you work harder on these things sometimes than you do in a real trial because you're obviously being evaluated by your peers and people are expecting you to be great, and that puts a lot of additional pressure on you than you normally would have. And when I was talking to Roy about doing this, not only, like I said, was he extremely gracious about the invitation, but I could tell that he's extremely passionate about being a trial lawyer. We spent a significant amount of time just talking about trial advocacy in the context of what we're going to do here. And I think it's amazing that a man who's been practicing as long as Roy has, with the string of successes and achievements that he's attained, that he still has that fire in the belly. And I think one of the reasons why he wanted to do the Helio Castroneves case was because it would give him an opportunity to revisit and think about giving a closing argument in a different way than he had done it before. I know he was excited to think about how can I tinker with it, how can I do things that maybe I wasn't able to do or didn't do in the actual trial. And I really think that as much as I consider myself to be a student of advocacy, I think that I'm not going out of my way to say that Roy, I think, still considers himself to be a student as well as a master, and I think that's one of the reasons why he is as great as he is. Okay, so if you've ever been on an airplane and trying to watch a movie, it usually begins by saying something like, this film has been modified from its original version. It has been formatted to fit the screen. Have you ever seen that when you're on an airplane? Well, Roy's closing has been modified to fit this presentation, okay? Obviously, none of us sat through a 6-week trial, have heard and seen the evidence, and obviously a closing argument is largely tied, if not almost exclusively tied, to the evidence that was introduced at the trial. So this is not meant to be a historical recreation of the closing argument that Roy actually gave, but rather a shortened and modified version of that closing argument to really illustrate some of the themes that Roy used in defending this tax evasion case, and also for you to get a sense and flavor for how Roy constructs and executes his arguments. So that's really the purpose of tonight. If you're like most trial lawyers, you haven't read any of the handouts that we give, okay? And that's fine, except I have to give you some context to the case so that when Roy does his closing, you know what it is he's closing about, okay? So if you'll permit me just a couple of minutes to try to give you a brief overview of what the government's allegations were, so that when Roy gets up here, there's some context to what it is he's doing. So as you've heard, the case involves Helio Castroneves, a 3-time Indianapolis 500 champion, who was charged, along with his sister and his lawyer, with the crimes of conspiracy to commit tax evasion and with numerous substantive counts of tax evasion. I'll lower that a little bit. The government alleged that Mr. Castroneves committed tax evasion arising out of income he received from 2 agreements that he entered into, or that companies controlled by him entered into with 2 separate companies. The first was a Brazilian import-export company called Coimex. And Coimex had entered into a series of 1-year sponsorship contracts with Mr. Castroneves in exchange for, they paid him $2 million in exchange for those sponsorships in consecutive years. So 1999 he got $2 million, year 2000 he got $2 million, year 2001 he got $2 million, so for a total of $6 million. The government alleged, however, that there was really an unwritten side agreement that Mr. Castroneves had entered into with the executives of Coimex, in which he, through the use of a nominee shell company called Seven Promotions, would actually, of the $2 million he would get in a given year, he would funnel back $1.8 million of that money to the executives at Coimex, so that the Coimex executives could essentially pocket this money with themselves not having to report Brazilian income tax. And now he's obviously not charged with committing Brazilian tax evasion, but was in the indictment presumably for the government to be able to dirty up Mr. Castroneves. The remaining $200,000 a year that Mr. Castroneves got, he also used 7 Promotions, this nominee company, to funnel off additional funds in such a way that they were then sent to offshore entities, so that of the $200,000 that he reported, that he actually got in income, he reported only a fraction of that. Okay, so that's the first scheme involving this company called Coinex. Okay. The second tax evasion scheme that Mr. Castroneves was alleged to have committed involved a contractual relationship that he entered into with a company called Penske. If you're a racing car driver fan, you're probably familiar with Penske. They're in the business of sponsoring and managing motorsports teams. And in 1999, Mr. Castroneves joined Penske as one of their race car drivers. And through his lawyer, Mr. Castroneves negotiated 2 types of contracts with Penske. The first was called a driver's agreement, in which Mr. Castroneves was to receive $1 million over a 3-year period. That contract, correct me if I'm wrong, but it was not an issue in this case. That contract, the money that he received, he reported as income. The second contract, and the one that was an issue in the case, was referred to as a licensing agreement. That was an agreement between Mr. Castroneves' government was a sham shell nominee company, 7 Promotions, and the people at Penske. And under this contract, Mr. Castroneves was to receive $5 million over a 3-year period in exchange for the licensing rights of Mr. Castroneves' name, likeness, and image. As I already said, the government's allegation was that 7 Promotions was nothing more than a sham nominee company that was in fact used and controlled by Mr. Castroneves in use for his benefit. But the government alleged that he used 7 Promotions as a way to hide his true income from the IRS by having 7 Promotions receive his income rather than himself. When Mr. Castroneves' company entered into this agreement with Penske so that 7 Promotions would receive the money, they ran into a problem. They were told by outside tax lawyers that the contractual requirement between 7 Promotions and Penske required that Penske withhold a substantial amount of that money for tax purposes as a result of IRS regulations concerning payments to Panamanian corporations, which 7 Promotions was. So as a result, Mr. Castroneves' lawyer instructed Penske, don't make any payments to 7 Promotions under the licensing agreement. Instead, according to the government, Mr. Castroneves and his lawyer hatched a new scheme. They set up something called a deferred royalty plan, similar to a deferred compensation plan. And in that plan, they required that Penske send a $5 million payment to an offshore company called Vintage Licensing, located in the Netherlands. And the setting up of this deferred royalty plan would not require Penske to have to withhold any taxes. However, outside tax counsel advised Mr. Castroneves and his lawyer that Mr. Castroneves would not qualify for the deferred royalty plan and would still owe income taxes if, in fact, Mr. Castroneves or any member of his family actually owned or otherwise controlled 7 Promotions. So to get over this hurdle, a number of phony documents were executed, and Mr. Castroneves and his lawyer falsely represented to outside tax counsel that neither Mr. Castroneves nor anyone else in his family had any interest or control over 7 Promotions. And as a result of these false misrepresentations, the deferred royalty plan was executed between the Netherlands company Vintage and Penske, and Mr. Castroneves paid absolutely zero on the $5 million of income that he ultimately received. Is that a fair summary of the government's case?
Of course not.
Of the government's case. All right. So that's basically, in short, what the case was about. With that, I will turn it over to Mr. Black to deliver his closing. The only thing I would ask is that you listen actively. What I mean by that is, I want you to think about questions you may have that you want to ask Roy. I know he's actually anxious to have participation in this process. So when it ends, I'm going to play Donahue, and I'm going to walk around with the mic, and also people on the web can submit their questions to the webcast, and those questions will be read. So I really appreciate you paying attention. We're very excited about the program. With that, Mr. Black, you may begin the program.
My friends at the government table have been arguing to you all morning that Helio Castroneves didn't pay his fair share of United States income taxes. In fact, they've been arguing that throughout the case, starting with their opening statement on through. But what they haven't told you is that our tax code is not based on fairness. It's not based on equity. It's not based on equality. In fact, taxes and fairness is an oxymoron. There's absolutely no necessity of any United States taxpayer to pay a fair tax. All you have to do is make a good faith attempt to file and pay the taxes that the code requires. And this idea of fairness is totally misguided, and you should reject it. Now let me tell you why. Is it fair that Mitt Romney pays his taxes at a lower rate than his maid? Is it fair that Warren Buffett pays taxes at a lower rate than his secretary? Is it fair that hedge fund managers and Wall Street billionaires pay a tax rate of 15%, while the average American pays ordinary taxes at the highest rate for their savings account? Is it fair that you have to pay a regular tax on unemployment benefits, while people who just invest their money pay a maximum of 15%? Is any of that fair? Is it fair that in 2009, our inheritance tax was 45%? In 2010, it was 0. In 2011, it became 45%. Not only does that have nothing to do with fairness, it's totally illogical. But that's how our tax code works. And that's not all. General Electric, Verizon, and Prudential, three of the most profitable corporations on earth, paid exactly 0 amount in federal income taxes last year. Google, one of the great companies of the world, actually pays at 2.4%. At least they pay a little bit more than these companies. And I'll tell you what is interesting about that. Even though they pay far less taxes than we all do, even though Wall Street billionaires pay less than we do, even though General Electric with 1,000 people working in its tax department pay nothing, it's all perfectly legal. It's all perfectly lawful under our tax code. So this concept that they're trying to sell you is that Helio Castroneves did not pay his fair share of taxes is totally misguided, and you should reject it. Now, while we're on, however, the concept of fairness, has the United States been fair to Helio Castroneves? I asked my friends at the government table, perhaps they can answer this when they get back up. He is here on what's called an O2 visa for athletic activities. That visa is only as good as he is working in athletics. As soon as his driving career is over, he has to leave the United States. Now, is it fair that he's never going to be able to collect Social Security? Is it fair that he's never going to get Medicare or Medicaid? Is it fair that he gets no education here? That he has to renew his visa? That at the whim of ICE he can be taken out of the country at any time? Is it fair that he has to report his traveling to them? And what happens when his career is over? And he's back in Sao Paulo, Brazil, and he's ill, and he goes to the drugstore and shows them his Medicare card and asks for the prescription. Do you think it's fair that they're going to laugh at him and tell him he doesn't get anything? So while my friends over here are talking about fairness, They ought to think about fairness to Mr. Castroneves, because that's where the unfairness in this case is. Now let me talk to you a minute about our tax laws. Our tax code is extremely complex. It has all kinds of provisions. It is very difficult for the average taxpayer to know anything about paying taxes or filling out a tax return or knowing about the laws and the regulations. Because of that, we have special laws that affect the American taxpayer. I know that you all know that, generally speaking, ignorance of the law is not a defense. But it is in taxes, because the Supreme Court has said, and the court will so instruct you, that a taxpayer must know the law and then must deliberately and intentionally violate that law to be guilty of tax evasion. If you make a mistake, if you try to minimize your taxes, even in an unreasonable way, but you do so through mistake, that is not a crime. It is not tax evasion. It is only tax evasion if you deliberately, intentionally, willfully, deceitfully, with a sinister motive, knowing the provision of the tax code that you're required to follow and that you intentionally don't do so. That's what's required to be convicted of tax evasion. So, you think Helio Castroneves, a dropout from high school in Brazil, whose first language is Portuguese, who was challenged in the English language and certainly in reading it, do you think that Helio Castroneves knew enough about the United States tax code to deliberately decide not to follow it? Our tax code, which includes the code, the regulations, and the revenue rulings, comprises 72,536 pages. Let's say you read 300 pages a day. It would take you 240 days just to read these things. That's assuming that you can read them. That's 1 year of business days just to read it one time. And then you would need, before you could read it, of course, it would have to be translated. Translated from the language that the lawyers write in there, all these tax lawyers, they sit around writing up all these regulations and codes. It would have to be translated into English just for us to be able to read. But what about Helio? He speaks Portuguese. Do you seriously think that he sat down and could understand a single word, well, maybe the and of our tax code? And that's not all. Our tax code is a maze. I think that statistics show us that last year, American taxpayers actually took a deduction of $6.4 billion to pay people to assist them with their taxes. They pay lawyers, they pay accountants, they pay bookkeepers, they pay all kinds of people because 85% of taxpayers cannot fill out a 1040 form. And those are Americans, not people from Brazil. Because our tax code is so convoluted, so hard to understand, that it is beyond the ability of the average person to actually work through it and file a tax return. Now just think about Helio Castroneves. Is there any chance that he could go through this maze and understand it? Albert Einstein was perhaps the most brilliant man who ever lived. In fact, when he died, they preserved his brain so they can try to figure out why he was so smart. He created the most famous equation of all time, E = mc squared. In 1905, he came up with the theory of general relativity. I would explain it to you, but it's challenged in physics. And in 1914, he actually thought up the idea of lasers. And it wasn't until 50 years later that people were absolutely finally be able to understand what he said and put it into operation. And yet Albert Einstein, this man who's such a genius, was challenged by our tax laws. And with all due deference to my client, he is no Albert Einstein. Nope, don't want that. We'll get there. And while we're talking about this, there's a very important principle when you're considering the case against Helio. We have a great principle in our law called the presumption of innocence. I remember when I was a young law student, I went to my class and the law professor was explaining this great concept of people are innocent until proven guilty. And we were all enthralled by that because what a great system we have. We're so invested in people's innocence and giving them a fair shake and a chance that we were just enthralled by this. And then they taught us this guy Blackstone, who had written on the English common law, and he came up with the formula of saying that it's better that 10 guilty people go free than one innocent person suffer imprisonment or death. What a wonderful idea. But unfortunately, a calamity has befallen the presumption of innocence. The presumption is now on life support. Today, in our culture, we no longer believe people are innocent. We think everybody's guilty. Everybody is a person of interest. We are willing to assume the worst of anyone. All we have to do is have their name come up in the tabloids or on the press or on television, and we are all too willing to believe that they are guilty. And we have suffered because of this. I'm sure some of you have read in the newspapers or television about how many innocent people have recently been released from prison. People who have been there for 10 years, 15 years, 20 years. Because of the DNA revolution, they were finally able to establish that they were totally innocent of these crimes. And at least 30 or 40 people on death row have been released. And why is that? Why have we gone from a system of justice where we were invested in innocence to one where we convict innocent people? It's because we no longer have any faith in the presumption of innocence. And this is highly unfortunate. I would ask each one of you, when you go back into that jury room, to invest in this principle because it's important. It's part of the fabric of our law, the fabric of our society, and this is something that is worth your consideration. Timothy Geithner is the Secretary of the Treasury of the United States of America. And as such, he actually is in charge of the Internal Revenue Service. Mr. Geithner, before he became Treasury Secretary, spent 5 years as the chairman of the Federal Reserve Bank in New York, dealing with untold trillions of dollars. He was a high executive at the International Monetary Fund, actually running global economics. This man, by any stretch of the imagination, is considered a financial wizard. The President of the United States nominated him as Treasury Secretary in order to save us from the worst recession since the Great Depression. We have invested a lot in this man's genius. But what happened at his hearings before Congress, we find out that Mr. Geithner, the financial wizard, the man who is going to save the world, actually filed false tax returns. It turns out he never paid unemployment taxes. He paid or took false deductions for a number of, not false deductions. He incorrectly took deductions for his children going to camp and to other kinds of activities. And he also withdrew money from his retirement account without paying the tax penalty associated with it. And all these things came out at his hearing. And what happened? The President of the United States said, well, those are just innocent mistakes that anybody can make. What did Congress say? Well, these were just honest mistakes that he made. What did the Internal Revenue Service say? Well, we don't think there's any problem that he made these kinds of mistakes because this can happen, so they certainly didn't charge him with anything. Not only that, but they didn't even assess civil penalties for the mistakes, the honest mistakes that he made. There's no doubt that mistakes were made in this case. But mistakes are not crimes. If you make an innocent mistake, if you make an honest mistake, even if you are a financial wizard and you should know better, that is not a crime. Because what the law says is that if you do the best that you can, in good faith, and try to pay your taxes, that is a complete defense. So long as you don't act in bad faith, so long as you don't have sinister motives, so long as you in good faith attempt to comply with the tax code, then there's no problem. It is not a crime. It is only when you know the tax provision and that you deliberately decide to violate it and you do not pay the tax that you know that you owe, then and only then, if you have that criminal intent, can it be a crime. If you make a mistake, like the Secretary did, or like Helio Castroneves did, that, ladies and gentlemen, is not a crime. And let's face it, we all make mistakes. I make mistakes. I made mistakes during this trial. Remember how many times the judge overruled my objections? I make all kinds of mistakes. And I'm, of course, willing to admit it. Human beings are not perfect. We are imperfect creatures. All that is required of us is to have throughout life, when we make mistakes, that we try to be better. We try to overcome them. We try to learn from them. In fact, isn't that what we do in life? Isn't that how we mature? By overcoming our mistakes and learning from them. And of course, that's the same thing with my life. There's no doubt mistakes were made in these contracts. That mistakes were made in bank accounts. That mistakes were made by bookkeepers. That mistakes were made in filing of returns. But these are not crimes. They are just innocent mistakes that cannot be punished as a crime. And the world's smartest people can make mistakes. None of us are immune. I just watched on television the inaugural of our new president, January 20th. Up in Washington, they had a magnificent program right there in front of Congress. And this is one of the great ceremonies that we have. The passing of the torch, a new president taking over. This is extremely well planned. We have and invest a lot in it. And millions of people are watching. Well, at least Democrats were watching. And we had two of the world's smartest people at that ceremony. We had Chief Justice John Roberts of the Supreme Court, obviously a brilliant man. And on the other side, we had Barack Obama, a graduate of Harvard Law School, editor of the Harvard Law Review, obviously also a brilliant man. And the two of them performed the oath of office. 35 words. That's all it was. And you know that they had rehearsed and practiced this many times. Yet the two of the world's smartest people couldn't get 35 words correct. Now, How do you expect my client to get his tax returns right? They can't even get 35 words right. And not only that, our government is certainly not perfect. What kind of mistakes do they make? All we have to do is take a look at recent history. Our tax dollars that we're talking about here, some $30+ billion of it goes to our intelligence services. Yet did they find a single weapon of mass destruction in Iraq, no matter how hard they looked? And what happened when Hurricane Katrina hit New Orleans? Could there be any bigger debacle than that? So, if we want to start casting aspersions, everybody makes mistakes. Even our perfect government with its representatives sitting over here. Now, I wanted to get back to a minute to this idea of intent, because intent is very important here. And as I told you, good faith is an absolute defense to a charge of tax evasion. And you heard the government just a few minutes ago talking about these various corporations and contracts and what have you. Now, what happened with my clients? They go to this Wall Street law firm that's charging them at $860 an hour. In fact, not only that, before the first meeting, they had already billed them $28,000. But putting that aside as it is, they create all these corporations and all these tax plans for Mr. Castroneves and his sister. And they sit down with him and they spend a few minutes explaining it. But Helio can't figure it out. So what does he do? The good faith in this case comes from two words. Nelson Burgess. You remember him. He testified here, seems like months ago. Mr. Burgess is a lawyer in Miami who grew up in Brazil, who's fluent in both English and Portuguese. So what does Helio do? This man who's doing this very sinister conspiracy, trying to steal money that is owed to the United States government, coming up with all these brilliant ideas of multinational corporations and shifting money around in all kinds of bank accounts. What does he do? He goes to Mr. Burgess and said, could you please explain this to me? Because I don't understand it. Now, ladies and gentlemen, I've heard a lot of things in my 40-plus year of trying cases, but I've never heard of a conspirator going to an outside lawyer to get a second opinion on their criminal conspiracy. But they go to Nelson Burgess, who takes these various contracts and companies, you'll see it all here on the screen, and he sort of tries to figure out what's going on. But that's not the only one. This was updated because Nelson is trying to figure out what is going on here. Now, if you notice, how many question marks are there on this chart? Now, this is not prepared by me. This is prepared by him. He said that he and his tax team couldn't figure out what to do. So he told Helio, what advice did he give him? Well, when you get the money, meaning when it's finally paid out by the bank in Holland, that's when you pay the taxes. And that's what he's doing. This is what the man who translated this from Portuguese explained. And by the way, I really love this chart. When I was a kid, they had this cartoonist called Rube Goldberg. And he used to create all these great political cartoons with all kinds of machinery doing some simple task and trying to take something simple and turn it into something extremely complicated that never worked. This is a Rube Goldberg contraption right here. And this has another piece of significance in our case. The court will tell you that if the taxpayer is confused about his duty to pay a tax, he then does not have willful intent to evade his taxes. If he's confused. Now, ladies and gentlemen, you must admit, taking a look at this, anybody would be confused by this, because this is extremely difficult to figure out. Now, one of the other principles, I don't want to say other principle, maybe this is even more important than the presumption of innocence, is the burden of proof. As you know, the government has the burden of proof. But what does that mean? What does this mean? I tried to put this together in some way that perhaps it could be understood. First, of course, is not guilty. That's easy to understand. But let's say that, well, you think, well, maybe it's only highly unlikely that, or highly likely that Helio is not guilty. Or perhaps he's likely not guilty. These are steps that you have to go through. Maybe you think he's probably not guilty. Or maybe you think it's unlikely that he's guilty. Or maybe he's possibly guilty. Or he may not be guilty. Or perhaps he's guilty. We're getting much closer to finding someone guilty. Or maybe he's probably guilty. Or maybe he's likely guilty. Or maybe it's highly likely that he's guilty. Well, ladies and gentlemen, under any of those findings by you, that means he's not guilty because there's a reasonable doubt. The only way he could be found guilty is if he's guilty beyond a reasonable doubt. Now, last night, I was thinking, how do I describe this idea of proof beyond a reasonable doubt? How can I get that across so the jury can understand it? Because you've never really dealt with this before. And I was thinking back, there was a program that I watched back in the early 70s when I first started out practicing law. It was this great program on PBS called The Ascent of Man. Had this man called Jacob Bronowski, who wrote it and narrated it, produced it, and it was a brilliant program. Bronowski was one of those one-of-a-kind people, an absolute genius. He worked at the Manhattan Project, building the atomic bomb. He was a physicist and a mathematician. One of these, geniuses that's off the charts. But after World War II, he went to Hiroshima and Nagasaki and looked at what happened. And he changed his profession from physicist to biologist. And this man was really a humanist more than anything else. And this series was a series of programs showing how man advanced in science and literature, in understanding and logic, and he went through eons of human development. And it was a brilliant program. But at the last program, he wanted to show the fear that can happen when people are so arrogant that they are. And he took a pilgrimage to Auschwitz. And he explained that much of his family was from Poland, and almost all of his family was killed in Auschwitz. And he goes behind the crematorium there, and there's a pond. And he walks into the pond, and he's saying that the ashes of his family could be there. And he gets down on one knee, and he puts his hand into the mud, and he picks it up, and he looks at it and said, this could be people's ashes here. And he looks at the camera, and he quotes from Oliver Cromwell, 17th century. He said, I beseech you in the bowels of Christ to consider the possibility that you might be mistaken. To me, That's the best description of reasonable doubt. Matthew, you want to do your commercial?
Yeah, sorry. I have to just do something, a commercial interruption.
You can count that part.
For those of you watching on the web, the code is closing 12. Closing 12. I'm required to spell it as well. CLOSING. Number 12. That's 1, 2. Is that sufficient? Thank you.
Thank you. One of my favorite college professors always quoted the line that when there's an elephant in the room, introduce it. The elephant in this room is Helio's father, Helio Sr. Helio Sr. is one of these very interesting guys. He is the one who created most of these corporations, who transferred most of this money, who signed all these documents, and he came in here and told you that. And of course, you watched him on the stand. He was a very commanding person, very sort of interesting guy, a little bit cracked, but an interesting person. Just think about what he was like when Helio was growing up. Helio Sr. is one of these frustrated athletes. He wanted to be a race car driver. That was his dream in life. And he raced and went up to stock cars and the field and what have you. But he just didn't have the talent. And he found at a very early age that Helio had incredible reflexes. And at 8 years old, he started Helio racing go-karts. And then sending him around Latin America. But finally sending him to the go-kart world championships. And sending him everywhere. He was obsessed with Helio becoming a race car driver. I'm sure those of you who have children, you've probably seen men like Helio Sr. You see them out on where the kids are playing, whether they're Little League or in Pee Wee football. They're the ones who are yelling and screaming. They're the ones who are grabbing the kids and shaking them. They're the ones who are complaining that they're not having a good game. That these people, you know these fathers who are over the top. Take that times 10, and that's Helio Sr. He is one of those kinds of people that must have been almost impossible to grow up. But of course, that's all Helio knew. And what did he do for him? Helio wanted to be a race car driver. And when you look on the right there, that's the picture, if you'll remember at the time when they had totally run out of all their money, run out of all their sponsorships. Nobody would even put their name on his car. His career was over. Until his father came in, his father sold his business, sold everything he had, put it into his son's career, invested every dime the family had, and his father took him from that to winning the Indianapolis 500 3 times and coming in second by a few thousandths of a second the 4th time. That's what this man has done. The government has said that you ought to convict Helio of a crime because of payments that he's made to his father. They say that his father did not do enough. Well, I suggest to you there's a real irony there. The problem is his father did too much. But here's a young man whose father and his family, his mother, his father, his sister, sacrificed everything for his dream. And what did he do when he finally reached his dream? Did he say, I'm going to forget you all? I'm going to go off and be at the Playboy Club? Or I'm going to hang out with models and I'm not going to remember where I came from? Not at all. He shared every dollar he had with his family. He repaid his father for all the time and money that his father invested in this, and our government has the temerity to say that's a crime. That repaying your parents is a crime. Now I thought, in this country, one of the great principles we believe in is family values. That we believe in the family unit. That we believe that we should be responsible for our children and our parents. And here's a young man who didn't run off and spend money at the French Riviera with models, but gave it back to his family. And these people have the nerve to say you want to send him to prison for that. In every religion, in every ethical society that I know of, one of the first rules is honor thy father and mother. No matter what you may think of Helio Sr., no matter what he may have done here, just think of the love of his son for his father and what he did when he became a success. This is not something we ought to condemn. This is something we ought to applaud. Now, when talking about how a son and a father have a bond, I just read this story recently that I think sums this up better than I can do. This old man goes up into the attic and he's taking out a number of albums that his wife had collected over the years. And he's looking through them and he finds a diary written by his son when he was in the second grade. And then he also finds one of the business journals that he filled out at the same time. And he put the two of them together on a table. And he's leafing through them, and he finds one day where the two of them wrote about the same thing. And he looked at his diary, and it said, spent the day fishing with Johnny, didn't catch a thing, what a wasted day. And he looked at his son's journal, and it said, spent the day fishing with my father, the best day of my life. Most of you, no doubt, believe that our tax code was developed to raise money to run the federal government. And there's no doubt that much of that is true. But there's a second reason. Our government uses our tax code to mold our behavior. By the way that they run taxes, they hope to change our activities. Let me give you an example. If they want you to make more contributions to charity, they give you a bigger deduction. If they want to heat up the housing market, they give you a deduction for your mortgage interest. If they want to develop new jobs, they give special incentives to business. Or they give incentives for bringing factories back from overseas back into the United States. That's how Congress and our government changes our behavior. Now, what's important in this case is that Congress decided they wanted people to create retirement accounts. They wanted people to be able to put money in retirement accounts so they would have something when they're old or when they're sick or when they can no longer work. I'm sure some of you are probably aware of this. You have Roth IRAs, you have 401ks, you can have various types of life insurance in which you pay no taxes until the time that you actually receive the money. This is part of a retirement fund. Now, this is exactly what was going on with all these contracts, or at least they attempted to do this with all these contracts with Helio. because they wanted to have something preserved for him when his career was over. Now, why was that necessary with somebody like him? Why would a young man in good health actually need an account like this? We're all, in this country, we love sports. We all watch it in the Saturday and Sunday afternoons. We watch football. We see these fantastic athletes running down the field. We see tackling, running, throwing. It's magnificent. We see people in the baseball diamond doing all kinds of activities. But what we don't see is what happens to these young men and women. We don't see them when their knees give out, when their backs are broken, when they have concussions and brain damage and can no longer work. They can no longer do any kind of sport. And they can no longer even work. How many of them have you heard that are out on the street? Or how many young athletes were taken up by the Don Kings of the world, or investment advisors who took all their money and they're destitute at 30 years old with broken bodies and cannot even make a living? That's why they designed this for Helio Castroneves. And I'm going to show you the video of where this case starts. It starts with a young man named Greg Moore. There was a race in 1999 at the Fontana racetrack in California where Helio Castroneves is 20 yards behind the car of Greg Moore when this happens. Okay?
Got to finish on a sad note tonight. Kart racers lost one of their own this afternoon after a terrible crash at the Marlboro 500. It happened just 10 laps into the race. Greg Moore lost control of his car at more than 200 miles per hour. As you can see, he hit the concrete wall of the infield. Paramedics rushed to his aid. They tried to resuscitate him in the infield. They then tried to take him to a nearby hospital by helicopter. They did everything they could to save Greg Moore's life, but in the end, the crash, as you can imagine, 200 plus miles per hour, it just wasn't enough. Greg Moore, just 24 years old, died today about 4:15 p.m. Eastern Standard Time. We'll be right back.
Helio was right behind Greg Moore, who was one of his friends. But it's not just the fact that this accident, this horrible accident, that gives rise to this case. But Greg Moore had signed a contract with Roger Penske Racing. Greg Moore is killed that afternoon, and there's a memorial service that night, which Helio goes. And he's approached by Roger Penske to take Greg Moore's place to ride for Penske. They need contracts signed immediately because Penske has advertisers who have to know who the drivers are. They had spent 6 months working on Greg Moore's contracts. And Helio has to step in immediately to Greg Moore's shoes. And part of the problem in this case is they took the contract, which I'll talk about in a minute, and just took out Greg Moore's name and put in Helio Castroneves' name. And that's what caused most of the problems in this case. But right now I wanted to point out, you want to know why they're worried about protecting his income so he would have some money when he finishes racing. All it takes is a split-second mistake. At 200 miles an hour, these young men are traveling more than a football field in less than a second. Their reflexes are incredible. Of course, that's why my client ended up winning Dancing with the Stars, because he has fabulous reflexes. But all you have to do is one mistake like that, and your life is over. Or you either go back in a coffin, like Greg Moore, or you're paralyzed or damaged for life. This is what they wanted to protect him from. I did some research about the Indianapolis 500 for the last 10 years. The average time between first and second place is 1.54 seconds over 500 miles. 1.54 seconds. First place, The average purse was $1.2 million. Second place, $600,000 for 1.54 seconds. That's the difference there is in these races and why these reflexes are so amazing and how easy it would be for a mistake like this to happen. So what happened with these contracts? I've introduced them all, and you can tell from the fax headers on top of the contracts, they were all completed on November 4th at 3 o'clock, 3:15, 4:30, and 10 minutes to 6. They were signed the next morning by Helio Castroneves at a large conference table when he didn't even get a chance to read them. And mind you, this is a man whose English is a second language. There are 5 contracts of 39 pages, single space, written by lawyers. Which reminds me. Not only that, but knowing lawyers as I do, it's filled with all kinds of provisions that no human being could understand. They have this concept called legal Latin. We've got some of those phrases in here. Legal French, we even have those in these contracts. The chances of Helio Castroneves understanding these contracts is nil. Not only that, we showed on one of the contracts, they have those little stickies with an arrow where they show you where to sign, and they had them on all of those. It's written in Portuguese, that this is where he's supposed to sign these English contracts. I mean, what better evidence do you need to know that this man didn't understand what he was signing? Not only that, because this was done so quickly, because of the pressure of time, they made a number of mistakes. They took out Greg Moore's name, but they left in the names of his corporation and how the taxes should be done. There's a little bit of difference between the two men. Helio is a Brazilian citizen who's a United States taxpayer. Greg Moore is a Canadian citizen who lives in the Cayman Islands, and I don't know if they pay taxes in the Cayman Islands, but whatever they do, that's what he was doing. So there's absolutely no chance that this young man understood these contracts that he was signing. And at a very minimum, if he didn't understand it, if they didn't explain it to him, which they did not, they didn't translate it to him, there's simply no way that he knowingly, intentionally, and willfully created this plan that was supposed to be deferred income to him when he retires or when he is injured. There's no way that he would understand that they screwed it up and that he is somehow responsible for this. Ladies and gentlemen, thank you for listening to me today. I want to leave you with 2 important principles, which I've already mentioned. First is the presumption of innocence. Every single person who comes into this courtroom is innocent unless the government can, beyond a reasonable doubt, find that he or she is guilty. The second is that the burden of proof is proof beyond a reasonable doubt. The highest burden there is in any proceeding anywhere. And the government has to undertake that burden. These are not platitudes. These are truths. These are simple truths, eternal truths. They have been handed down to us generation after generation. They are part of our inheritance as Americans. The architects of the great documents that founded this democracy created these rules. This courtroom is hallowed ground. This is the place where justice is done. But for many decades, people suffered the heat of injustice. They suffered because of bias and prejudice and hatred. We have done all we can to root out those evils because we believe in the ideals of America. We believe that America is a beacon of freedom and hope to all the oppressed peoples of the world. We believe that the weary travelers who seek freedom and justice will find it here. May God be with you in your deliberations. May God be with this honorable court. And may God bless the United States of America.
That was incredible. And you were so in the zone that I had forgotten I was supposed to give that moment, but he didn't, which is really astonishing, without any notes in his head. We have very little time, so what I thought I would do is just take one question live, and then one off the webinar to be fair to the folks on the web.
Sorry, I went too long.
Oh, it was great.
Hi, Roy.
Yes, ma'am.
At a lot of CLE seminars across the country, there seems to be a trend among speakers arguing that today jurors expect that defendants will prove their innocence, and that we should no longer be making the efforts that we had in the past to convince people that there is a burden of proof on the government and there is something called a reasonable doubt, that we should be making our arguments by saying this is what we're going to show and this is what we're going to prove. And it seems like those of us who still believe that jurors think that the presumption of innocence is important are laughed at as being naive. But in your presentation, you seem to spend a good deal of time defending the presumption of innocence. Have you seen this debate, and what do you think about it?
Well, I haven't really, nobody has ever said that to me, and I think that it's a big mistake. And I'll tell you one thing that I suggest for any, particularly the young lawyers here, or even older lawyers, that I think that you have to develop. The problem with the final argument, particularly on the defense side, it's very hard to prepare it in advance because so much happens during the trial, and you have to worry about, each little fact. Here, I really just hit the themes. I didn't give the part another hour or so on all the little details and facts. But having said that, I think we need to prepare set pieces. John, this is what I'm getting to your question. I think you have to have a set piece for the presumption of innocence, for reasonable doubt. So you can give that without thinking about it. So you already have it prepared in advance, because it's hard to draft these things up the night before, the weekend before, during the trial. You need places where you have these set pieces where you don't have to think about them, that you just do it, and then you're thinking about what you're going to say after that. So I'm a believer in that, in trying to prepare as much in advance as you can. And another thing I wanted to mention, and A.P. and I talked about this as well, and I've written about it. I think that the beginning of the argument is one of the most important parts. Whether it's your opening statement or your final argument, that first paragraph, that first minute has to really hit people and get their attention. And I did the presumption of innocence probably the third or fourth thing that I talked about, because I think it ought to be moved up. And I know I probably can't use a photograph of Nancy Grace in a real trial, but I think that's what makes the point. And then, of course, I want to hit reasonable doubt somewhere after an important point I make, and then I want to tie it all up at the end and bring it up again. So there's a theme throughout the argument that there's a presumption of innocence, there's a burden of proof, reasonable doubt, and I try to come back to it as often as possible because I think that jurors take that seriously. And it's our job, if they don't, is to convince them that they have to. And this idea that we ought to just ignore the best things we have going, I think is foolhardy.
A question from one of the folks attending my webinar. In preparing a persuasive closing argument, are you anticipating what the government's rebuttal would be? And if so, how do you do it?
I hate rebuttal. I have sat through I don't know how many rebuttals, sitting there thinking, why the hell didn't I think of that while I was arguing? You know that this is the worst thing, when you have to sit there and you can't say anything, and they're picking apart what you said. And what I tried to do is to think out the real weaknesses of my argument, of my case. But it's painful. It's painful to talk about them. So you have to somebody get into it. But the worst is when you forgot something like that and they stick it down your throat in rebuttal. That is one of the most uncomfortable things to do. So you have to think out what the rebuttal is and try to handle it as best as possible. But there are always going to be things that you didn't think of, or for some reason you forgot when you were arguing, and the government is going to kill you with it. I wish I had the power of rebuttal.
Well, I want to thank Roy for a phenomenal presentation.